So the overarching theme of this year, ECB Legal Conference, is how to build European autonomy in a way that remains true to the rule of law, sustain trust in international institutions, and keeps international cooperation alive. In this context, we thought that the discussion would be very useful with a reflection that is sometimes on a topic that is sometimes overlooked, but it goes to the heart of the matter and also to the heart of the work that most of us, I think, in this room do. So the role of the legal services in building a European autonomy in a way that remains true to the rule of law. This is in a way a soul-searching exercise, but not only. It is actually also a discussion that is taking place. There are some people in academia that argue that legal services are actually influencing the case law, influencing the courts, and therefore making law. And there are others that say legal services are just rubber stamping. They do, they confirm political decision. They're just there. Now, neither of these two can be true, actually. Probably the truth is a little bit in the middle. I think we pride ourselves with contributing to the analysis by the courts of legal issues, so that maybe we do sometimes manage to influence, and we certainly try not to rubber stamp, rather to contribute to the decision. In any event, today we will have a possibility to discuss this. So you don't see, this is a round table. Yeah, it's a little bit straight, but it was not possible to bring chairs there and do all the other nice things. We will nevertheless discuss around here. We have one panelist online because for serious personal reasons, she could not join in the end physically, Ian Liu, the General Counsel of the IMF, and we're very grateful that she has managed to connect online because we would not like to do without her expertise. So what we will want to look into is a number of things. There is Liu, Ian. Ian, hi. You hear us? Thank you very much for being with us. So we would like to
being there in person. Yeah.
Yes, it's a pity. It's a pity, but thank you for at least managing to be here virtually. So the first point is the role of the legal service as a guardian of the rule of law. Now, both at the EU and IMF level, and also in the case of national central banks, there are a number of cases that sometimes come to the court and reach adjudication, which means in practice that it is for the legal services to safeguard the rule of law, the good governance, the public trust, to defend the institution and show that the institution is acting properly on the one hand, and act within their competence, and on the other hand, also remind the institution that the fundamental principles are always there. Yeah, even when you do the most small technical thing, that doesn't mean you should disregard that. So, guardians of the law. The second point is the dilemma between transparency and confidentiality of the legal advice. These are common issues that we all face. So we need to strike the balance between the confidentiality of the advice we give to the decision makers so that they are free to take their decision, and the transparency that as public institution we owe to the citizen who want to know how decisions have been taken and how to tackle that issue. Another topic that is very prominent is the political pressure, especially in situations of urgency and of crisis. We all know, colleagues, this situation. Someone comes to your office pressing for action. We need to have a decision done by tomorrow. How do we facilitate that action, try to find a solution, a legal solution to have the action needed, but still maintain a role as independent advisor to recall the principles that we need to abide by in our legal, institutional action. So how can we remain independent advisor, defining the limits of the legality? And the last point I would like to also consider accommodating us is the role of general public international law. So we have our focus, it is national law sometimes, it is European law sometimes, IMF rules in another case of Jan, but international law is increasingly under threat. So should the legal services place more emphasis on integrating its principle into our work, or is it irrelevant? For example, we had just a panel this afternoon, actually was still this morning. We had a very intense work on international law when the European Union confronted itself with the issue of sanctions. Let me briefly introduce the panelists. I know them very well. They are colleagues for many years and actually friends. So I have here at my left Daniel Calleja Crespo. He is the Director General, take this mic, of the Legal Services of the European Commission since July 2020. But before that, he has been always a big animal at the Commission. So in the present capacity, he advises the College and the Commission and represents the Commission in international jurisdiction and national. Before that, he has been Director General of Environment and also Internal Market, Industry, Entrepreneurship and SME. And I spare you all the other high position that Daniel held. Anyway, he has a long career at the Commission. Freddy is another long-time friend. No, friend, I said. He has been the jurisconsult of the European Parliament and Director General of Legal Service since 2013. And he advises or does his best to advise the Parliament about legal issues and represent the Parliament in the proceedings in the Union and actually even recently in national jurisdictions in some cases. Yeah, so very challenging proceedings sometimes. He also has held many senior positions in the Parliament, including Head of Cabinet for the Secretary General and Director for Legislative Affairs. Lucia is also a dear friend. She is the Director of Legal Service of Banco de España, and she has been with the Central Bank of Spain since 2004. I think we should stop saying all those dates at this point, but okay. She worked before at Bank Inter and Garrigues in Brussels, and she studied in Madrid, in Bruges, and at the Istituto di Impresa. She's an active member of the legal committee of the ECB and also of the Monetary Law Committee and of the European Banking Institute. So she spends her free time in very legal activities as well. And then online, unfortunately, but thank you for being here, Ian Liu is the General Counsel and Director of the Legal Department of the International Monetary Fund. She is the advisor of the IMF Executive Board, management staff, and she advises on the every aspect of the fund legal work. It's a very broad area, from lending to financial sector reforms to insolvency framework. So she has led the legal department through some major reforms lately and also IMF lending policies. Today, as I said, we have to see her only online, but in case you meet her somewhere, she's a wonderful person to meet. So let me now open the discussion in this round table, and I would like to turn to Daniel first and ask Daniel, in your capacity as the Director General Legal Services of the Commission, there is a particular role of the Commission in protecting, I would say, the rule of law. So the Commission is the guardian of the treaty. The rule of law is a very important principle of the treaty. The legal service has been involved in the process that lately has made the rule of law a much more justiciable principle than one thought some years ago. Can you tell us a little bit about that and also on the role that the legal service played in this?
Thank you very much. It is a great pleasure to participate in this exciting conference. I want to thank the European Central Bank for the invitation, and I want to thank Chiara Zilioli in particular. She's a dear friend for many years. I have always admired her leadership, in many different European institutions, and she is a friend in spite of the fact that she called me animal, which I did not expect. But as an animal from the Commission, I would like to discuss the role that we have played in the rule of law. But first of all, I would like to share with you a few facts of what is the legal service of the Commission, who we are and what do we do. Because some months ago, I attended a conference of the French Conseil d'État, and to my surprise, the title of the conference was Le service juridique de la Commission, c'est grand inconnu de la construction européenne. And say, how can the legal service of the Commission be the great unknown of the European? Because we tend to be very proud about what we are doing. So you have to bear with me. I will be very brief, but I have to share some facts with you. The legal service of the European Commission, I do it with a little bit of embarrassment because now I have to try to sell a little bit what we are doing. But we are one of the oldest services in the Commission and in the European Union. It started with 3 lawyers in 1951 with the creation of the European Coal and Steel Community. One of the first services which was needed was the law, the legal service. In 1957, there were 3 legal services for the 3 different communities, EEC, Euratom, and ECSC. And in 1967, it became the legal service of the European communities, which is the predecessor of what we have now. From these 3 lawyers, today we are 350 lawyers from 27 different nationalities working in 24 different languages. You will say 350 lawyers. This is huge. It is not the quantity, it is the quality which really matters. And so that you can evaluate what we do, we are representing the European Commission in 3,000 cases before the European courts, General Court, European Court of Justice, Strasbourg, European Court of Human Rights, where we intervene, WTO, and in any international jurisdiction. So we are litigators in the sense that we have the exclusive representation in litigation in the courts of the European Commission. At the same time, from this role of defense, we provide internal advice to the Commission. Every year, we have to give the legal opinion in around 15,000 proposals. Not only regulations, we don't do 15,000 regulations, directives, or decisions, but in any act which goes to the College of Commissioners requires the positive opinion of the legal service. The legal service is under the direct authority of the President of the Commission, and the Director General of the Legal Service attends the meetings of the College. I do not have the vote, but I have the voice. If there is a question, a legal question, the adrenaline increases. It's like when we are in front of the court, because you have to give the right reply, hopefully, when you are questioned by the College of Commissioners. We are a service of services, and our position in the European Commission gives us a very important role, because being under the authority of the President and being the only service that attends Commission meetings, you are primus inter pares. You have the possibility to have influence. Now, besides the advisory role, besides the litigation role, we also have a third role, which is better regulation. This is the most challenging, quality of legislation. There is a group of lawyers, linguists, who are checking the texts, the coherence. Why is it so important for international organizations, for our institutions to have a central legal service? I think there are 3 very important reasons. The first is independence. Only legal advice, which comes from a central legal service, can ensure the full compliance of the institution with our rules. If we were split to many legal services, this would lead to fragmentation. So it is crucial for every organization to have a central legal service. Second, the Commission is guardian of the treaties. So we cannot afford to have weaknesses in terms of the legal advice. We have to lead by example, and it is very important that all the legal acts that are adopted by the College have the certainty of compliance. If the legal service issues a negative opinion, and we don't issue so many, but from time to time, the file has to go to the College of Commissioners. Last but not least, it's about independence, it is about coherence, but it is also about our commitment to multilateralism, to international law, to rules-based organization. I think all the legal services of the institution share this. How have we acted in relation to the rule of law? And I think here we have to start first. The first thing we have to say is to underline the crucial role of the European Court of Justice in developing the principles justifying the rule of law. Article 2, where we have the values of the Union, and Article 19.1, which enshrine the principle of effective legal protection in the light of Article 47 of the Charter. Following the seminal judgment of the court in the case of Asociación Sindical de Jueces Portugueses, I say it the Spanish way because my Portuguese is very poor, the court established its jurisdiction in ensuring the possibility to control the respect of these principles. And this came as a big surprise to many because we had never expected that there would be such a vast number of cases dealing with the rule of law. There have been more than 100 cases in the past years concerning the rule of law. And here we have a certain number of principles which are very important. The values of Article 2 are legally binding. They define the constitutional identity of the Union. They are subject to the principle of non-regression. They are conditio sine qua non to become members of the Union, and we need the means to defend those values. And I will mention 3 examples on how we have acted to defend these values. The first of all is in legal procedures. We have had the possibility, or we have had the duty, regrettably, to intervene through infringement proceedings when the values of Article 2, in particular judicial independence, were under threat. And the Commission did not hesitate, following the advice of the legal service, to take countries before the European Court of Justice in order to ensure that the judicial independence was respected. Thanks to all these cases, the Court of Justice has ruled on the independence of the courts, on the removability of judges, on disciplinary regimes, on independent judicial review of decisions affecting the judge's situation, and even on the remuneration. This was done through infringement proceedings, but also in many preliminary rulings, because the judges under threat went to the European Court of Justice seeking redress. In all preliminary rulings, the legal service of the Commission intervenes as amicus curiae to help the European Court of Justice. And we do this systematically in all cases in the language of the judge who presents the question. So these have been very important procedures which have allowed us to show that the rule of law is a meaningful principle. Not just declaratory judgments, but in some cases, we have had some breakthroughs in the jurisprudence, like the imposition of sanctions to countries who were in breach of the rule of law. There was a particular member state who was ordered to pay a daily penalty of 1 million euros for failing to comply with an order of the court to suspend certain judicial provisions concerning disciplinary measures against the judges. The muscle law. I will not mention the country, but you can imagine what it is. Since the country refused to pay the fine, the European Commission applied the EU recovery mechanism and deducted these fines from the funds that had to be paid to this country for a total amount of 320 million euros. This was confirmed by the General Court, and there is a pending case, there's a pending appeal, but this shows that this is not just about principles, this is not just about theories, this is meaningful and can actually have, with the support of the court, we can impose sanctions. And I'm finishing with the 2 last examples, which are also known. The conditionality regulation. The conditionality regulation is a very powerful instrument adopted by the Council and the European Parliament, drafted with a very, very important contribution from the legal service, which allows to condition the financing by the EU budget to the respect of the rule of law, where the financial interests of the Union are at stake. Again, there is another country which has been blocked 65% of its funds by implementing this mechanism. Last tool, I will end there because my colleagues need to intervene on other points. we have not just been at judicial proceedings or legislation. There is a very important new instrument, which is the rule of law report. Every year, the Commission examines the situation of rule of law in the 27 member states. We examine the state of judicial independence, freedom of the press, fight against corruption, and checks and balances. And we include recommendations. For the first time, we have also included in this list the candidate countries. 66% of the recommendations addressed to the member states have been taken on board, and this is another very useful tool. So, in a nutshell, I think the legal service is fully committed to play its role, to advise, to give the best independent advice to our institution, but also to actively ensure the enforcement of our rules, the respect of the rule of law, in a meaningful, in an effective, and in a timely manner. Thank you.
Fascinating. Not only the amount of lawyers you have, the quantity of work done, but also the quality, because it's easy to talk about the rule of law as a principle, but then the rule of law needs to be applied, implemented, and enforced. And all this is done through the participation in the court case, in which you act also as a supporter to the court in the analysis of the issues, especially when you intervene in prejudicial, but also, as you mentioned, when you impose the sanction on the countries that try to refuse to do that. And the report is a very important report. The ECB has contributed. There was 1 year in which all the institutions were asked to contribute. We also did contribute. I think it's important because it also draws the attention to all the institutions, all the states, to what you can do. What is your role? What is your space? And it's not just a principle up there, but it's for everybody. So the Commission really has an important role, and the legal service is the arm, the operating arm, if you want, of this strong principle in the Commission. Thank you. So I turn into this roundtable to my right to Freddie, and being the Parliament, of course, the most political institution by excellence, I would like to ask you, Freddie, how do you navigate the provision of independent legal advice in a very political institution? Maybe you can tell us some stories. Thank you.
Thank you, Chiara. And first of all, thank you for the invitation. It's a pleasure to be here. And thank you to Daniel for having broken the ice, because it makes my job a bit easier, because a lot of what he said, I can take over. But Chiara, I just pick up on your words. We are not the armed arm of the Parliament. Parliament is a political institution, that's true, but the role of the institution is different from the role of the Commission, of course. So this applies also to its legal service. We are different, but we nevertheless have the same aims in a way. We are much younger. In fact, I think we are the youngest legal service of the institutions, at least the oldest institutions, because we were created in the second part of the 80s, 1986 to be more precise. We count altogether more or less 135 colleagues now, when the recruitments that we have started are over. But we also have a difficult situation because we are geographically split. Half of the service is in Luxembourg. Historically, it was as a whole in Luxembourg. And now half of it is in Brussels, because this is the place where parliamentary business takes place. We cover as a service, so of course, as a service, we need to cover all the national systems, all the working languages, but we cover in terms of activities, legislation, of course, parliamentary affairs, so immunities, recovery procedures. You alluded to some of them in your presentation. Tender procedures, staff issues, contracts, budget issues, and buildings. And buildings, that is a considerable part of our work. I could say a lot about that, but maybe it's better to save some time for the discussion later on. Our motto and our principle is that we have to deliver frank, objective, and comprehensive legal advice. Of course, these are the criteria of the Turco judgment, and this is our compass, and in a way, it's also our shield, because this is the way we can, what was the verb you used? Navigate, and navigate in a safe way. What is the legal framework in the European Parliament which applies to the legal service? So basically, it's a bureau decision, the bureau being the political body where you have the president, the vice presidents, and the quaestors, and they have defined in 2004 the way the legal service of Parliament engages in activities. So basically, we intervene at the request of the President of Parliament, of course, the Bureau, the Conference of Presidents, the quaestors, parliamentary committees, parliamentary delegations, rapporteur, and in a certain way also individual members, but in another form, I would say. We also intervene for the administrative business at the request of the Secretary General and the Directors General of the Secretariat of Parliament. The basic rule is for us the rule number 22, paragraph 4 of the Rules of Procedure, because there it said that Parliament shall be represented in international relations, ceremonial occasions, and in administrative, legal, and financial matters by the President, who may delegate these powers. And in fact, these powers are delegated to the head of the legal service. Our cornerstone when it comes to the functioning of our service, when it comes to introducing cases before the court, is the Legal Affairs Committee, which is the voie de passage obligée, which is the committee we need to go through before bringing an action to the court. There are also internal rules where the legal service needs to be consulted. This is also very useful, so the big principles are taken on board, and it also helps when it comes to assisting the services at a later stage when it comes to implementation. So how does it work in practice? So in fact, there is no legal obligation in the European Parliament or when it comes from its organs to follow the advice of its legal service. Members decide, the bodies decide, but they have to decide on an informed basis. It's also a question of responsibility at the end of the day. So, in fact, the authority of the legal service derives in a large part from its credibility and the quality of the legal advice it provides. And of course, we also have to recognize that it's more than unlikely that an advice we produce will please everybody and be taken on board by everybody in the House. That is, let's say, an illusion we have to live with. So that means, and there I refer to a statement of Professor Päivi Leino-Sandberg, there is some kind of a free market of legal advice in Parliament. That's just the way it is, because normally individual members or political groups don't have access to the legal service the way the constituted bodies have. But I'll come back to that with an anecdote at a later stage, if I may. What is important for the legal service is to remain impartial and avoid to be instrumentalized, of course. And this all means that we have to work and situate ourselves always within the Turco criteria. This also means that we have to understand and to take account of the political context and the Parliament's strategic interests. This is always present when it comes to give legal advice, and this advice has to be useful and relevant in practice, while always maintaining impartiality and credibility. And now I come to the anecdote, because like Danielle, we sit in the meetings of parliamentary committees, in the meetings of the organs, so the Conference of Presidents, the Bureau, and sometimes are given the floor. And I remember that I had to present a legal opinion concerning an inquiry committee. And this legal note that we had drafted didn't please some group chairs, and one of them was pretty vocal. And after a certain discussion, a certain while, the president just said, "Look, I'm sure that the jurisconsult is more than willing to, after the meeting, accompany you to your office where you can continue that discussion." So this is what happened. What was the first thing that this group chair did? He took the legal opinion, scanned it, and sent it to somebody. So far for confidentiality. But we had the discussion and we didn't agree. A few days later, he came back and said, "Look, I have here a legal opinion of a famous representative of the academic world. He comes to different conclusions." And I said, "How much did you pay?" He gave me the figure and I said, "For that price, maybe." No, I fully maintain what I wrote and I stick to that. So it is part of a reality. But to come back to a more serious anecdote now, and to make the link directly with the rule of law, I would just take as an example the adoption of the regulation on the budgetary conditionality, or the rule of law conditionality, or depending on the way we quote that regulation. So we knew right from the beginning that the legal basis is Article 322, paragraph 1, letter A, which concerns the rules governing the implementation of the budget. So this was crystal clear for us, maybe not to all members. So the proposal was written in a certain way. The file was attributed to the Budgetary Committee jointly with the Budgetary Control Committee. And the Civil Liberties Committee was associated. So the perspective coming from both sides were sometimes slightly different, if I may say so. For us, it was important to remind members that it is key to remain within the scope of this budgetary legal basis, because it was more than obvious that sooner or later, in fact, it happened sooner than later, we will end up in court and we would have to justify, and you always have to keep in mind also that you give a victory to a member state who doesn't follow the rule of law. This is not a very nice perspective. And there I must say that we have worked very closely with the Commission, with the Council, with the colleagues of the respective legal services, and finally it worked out. Just to give you an idea, the LIBE, so the Civil Liberties Committee, wished to introduce elements like a rule of law monitoring panel with broad competencies and investigative powers in member states, and not forcibly with a connection to the budget. So we had heated meetings, heated discussions, and we had warned about the risk that such elements could be struck down by the Court of Justice if a member state would challenge the regulation, which happened. And finally, at the end of the day, the lead committees pushed to amend the Parliament's position in the light of the legal opinion which was given. And in fact, as was said, this regulation was challenged and paved the way for milestone judgments, Poland versus Parliament and Hungary versus Parliament in this field. It's also a question of credibility and of experience, because our credibility as advisor during a legislative procedure is directly linked to its role as defender of Parliament's interest before the courts. And this is for the moment after that the legislation has been adopted, but it also has weight when it comes to discussing the position to be taken before the adoption. As I said, the legal service must be frank and objective and give advice along these principles when we discuss with the Legal Affairs Committee before asking the question, do we go to court or not, so that the members make an informed decision. It might also be so that every now and then we go to court, but maybe that we are not totally convinced of the case, but that doesn't matter. We are professionals and we always make the best of it. Just to finish my example concerning the conditionality regulation, we had to go to court. We had to introduce a failure to act case against the Commission. And finally, the Commission notified a member state after the entry into force of the regulation. And this has permitted Parliament to withdraw its case after another discussion in the Conference of Presidents, where some were of the opinion that we could continue just to see. And finally, we managed to withdraw the case, and it ended up with the two judgments where all the institutions and the 10 member states which intervened had prepared very well and were on the same line, more or less. So maybe I'll stop there with that example. I could continue with more administrative files. I could mention the COVID pass control situation, but I leave it there. Thank you.
Thank you. It will be highly interesting, but I would like also to give the floor to the other speakers. And I think we got an impression of the complexity of your navigation in, in the Parliament. So I look at Lucia. Lucia is the head of legal service in a central bank of a member state, and also a member of the legal committee, and in the capacity of being part of the Eurosystem. There she also has the responsibilities to implement and explain the law of the ECB, let's call it this way. So it's a double responsibility that maybe sometimes has its difficulties. And I would like to hear from you, maybe if you can express these two aspects, and if you ever were in a situation where you found it a little bit difficult or challenging, let's put it this way.
Well, thank you very much, Chiara, and thank you as well, the colleagues of the ECB Legal Services, for inviting me. And it's a pleasure being part of this roundtable with distinguished speakers. Also, because I think that the fact that a national central bank is talking about how we contribute to EU autonomy and to the EU rule of law is a good example of how unique the European system of central banks is. And this is something that has been recognized by the European Court of Justice in two judgments in Rinseviks, also in the Commission versus Slovenia, where it defines the European system of central banks as a unique legal construction and a highly integrated system where that brings together the European Central Bank and national central banks. And therefore, because of this unique legal system, I also think that the legal services of the national central banks also contribute to the EU autonomy and the rule of law. So I think that the fact that we are a part of this very unique legal system makes us as well very unique in our jurisdictions. And for instance, this is there's no comparison with any other national authority because we have precisely this dual role that you say. On the one hand, we are an integral part of the Euro system. And then we have to comply with the treaty, with the statute, and with the ECB legal acts, with EU law that applies directly to us. But on the other hand, we are also a national public authority that is embedded in the jurisdiction and in the constitutional framework of our countries. We are subject to national court review, national accountability before the national parliaments, and national law. And for instance, we apply national law when we implement monetary policy decisions through the principle of decentralization. And we also do apply national law, for instance, when we apply when we carry out national tasks. So going back a little bit to your question, how we deal with this dual role, let me take you back to my holidays. I only started work yesterday, sorry. So it's still fresh in my mind. Tomorrow I'll be in the office. This is not exactly holidays, but it's a good in between. So I went to Tarifa, which is a town in the south of Spain. It's the most, Daniel is going to confirm everything I say, and he's going to prove that this is frank advice and independent advice and accurate advice. So Tarifa is the most, for those of you who don't know, is the most southern tip of the Iberian Peninsula. It's in the Gibraltar Strait, and it's only 14 kilometers away from Africa. So it's really down south. And Tarifa is very well known because it is the meeting point between the Atlantic Ocean and the Mediterranean Sea. And please confirm, Daniel, it is extremely windy. Because of this unique position, you receive winds from the north, from the south, from the west, from the east, and therefore it is a haven for kite surfers, windsurfers, but it is extremely windy. So when I was thinking during the holidays about the question of how we deal in the national central banks with this dual role, there's this beautiful promenade and boardwalk in Tarifa. Now everybody's going to go to Tarifa. I can see it. And you have to the right the Atlantic Ocean, to the left the Mediterranean Sea. And that's a little bit how we feel, I think, in the national central banks, because we are the meeting point of EU law, national law, and EU jurisdiction, national jurisdiction. And, it's we navigate, we windsurf those two waters, and sometimes it gets windy. Not all the time. In Tarifa is 300 days a year, and it's not as bad for the National Central Bank legal services, fortunately. So I think that now you picture a little bit more or less what it is like. And I know that part of the academia, and some of you may be of that or might be of that opinion, think that this dual role for us it represents an inherent contradiction, conflict of interest, and so on. I personally do not think this is the way. If you wanted to be provocative, I'm going to do it so you wake up. You could even say it's a little bit schizophrenic because you need to comply at the same time with two different legal frameworks and with two different sets of responsibilities, ECB and national responsibilities. But I don't know if maybe because I've been working there too much and maybe I need to go to the doctor, but I don't think it's schizophrenic. And there are two reasons why I do not think or I do not feel that way about the work we do. First, because as in the Parliament, as in the Commission, as in the legal services of the ECB, the work that we need to do under the two dual hats and dual roles is the same. We need to provide the best independent, accurate legal advice we can. So that helps us a lot navigating the two roles, because the way we need to process and structure and face the issues we're confronted with is always the same. We need to provide the same legal advice. The same good advice. And the second reason is because very often you see that one side complements the other. So by defending the independence of the institution, the rule of law in the national arena, we reinforce as well, we make it stronger, the rule of law and the independence of the system as a whole, precisely because we are an integral part of that system. So if one NCB was independence was in jeopardy, it would make the ECB weaker, because the governor of that NCB is an ex officio member of the decision-making body, ultimate decision-making body, which is the governing council, and it would make weaker the system as a whole. So that also helps a lot, the fact that there is common complementarity. So by defending one independence in the national sphere, we also make sure that the system as a whole is more resilient. Again, like the windsurfers or any good sailor, you need to know how to navigate, how to read the waters, how to use the wind to your advantage. And in the legal services of a national central bank, it is very important to have a deep knowledge of EU law, or ESCB, at least more a part of EU law, at least, and deep knowledge of national law. And also it is very important to know how both interact and how we can make them work together. And for that, fortunately, the national central banks, we have tools at our disposals. And in those occasions, it is extremely useful to apply the general principles of EU law as they have been interpreted by the Court of Justice. So, for instance, very often we have to think about lex specialis versus lex generalis, or we have to think about the principle of independence as it has been interpreted, or we have to think about the primacy of EU law, which is like the last resort we always go to. I think that at least in Banco de España, we're very fortunate because the primacy of EU law is also recognized in our statute of Banco de España. So in our laws, it says that first and foremost, we need to apply EU law, and only as much as it is compatible with EU law, then we apply national legislation. And this is extremely useful for us because we don't need to invoke so much the direct principle of primacy of EU law, but we apply our articles referring to it. So those principles are extremely useful. And this, I think, it will be my last remark here. And then if you want, we can later discuss about conflicts and so on. But my last remark would be that precisely because our position is unique in our jurisdiction, there's no other national institution that has, if you want to look at it as the privilege of setting aside national legislation if it is incompatible with our ESCB legal framework, we need to, this comes with a huge responsibility, which means that, of course, it is extremely important dialogue, active dialogue with other national authorities. We need to explain our legal framework. They need to know why independence is there, why it is necessary, so they understand that we are not trying to shield ourselves behind, it's not about defending privileges, but it's necessary and is there is for a reason. So national dialogue with other national institutions is extremely important. Communication with the public, it is extremely important. So they understand how we operate. And also, of course, national court review is also extremely important. So I would stop here for now and then.
Thank you, Lucia, very much for this perspective that maybe some people appreciate very well, those who are in SCBs, but maybe others have is new to them. Jan, I would now have a question for you. Now we have seen the European institutions' perspective, the dual role of a national central bank in the Euro system. What is in the IMF legal department the role of legal service trying to uphold the mandate of the IMF itself, while in a situation as we are today of changing rapidly the global environment and some emerging challenges? How do you, I use again the word navigate, it seems to be very useful today. How do you lead your service and cope with this increase in geopolitical fragmentation? You are really a global institution. Thank you.
Let me first join other speakers in thanking ECB and also Chiara yourself for your kind invitation. It is a real pleasure to join this great panel, and apologies again that I could not be there in person. I think it's quite timely to discuss a topic, in my view, is very central to the IMF's institutional identity as we continue to, as you're saying, navigate in a rapidly changing world. To really better understand our role, I think it's important to first reflect on where we began as an institution. I think, as all of you know, the IMF's legal framework was established back in the 1940s in the aftermath of a devastating global conflict. So it was built really on a collective post-war consensus that multilateral economic cooperation was essential to global peace and prosperity. So the Articles of Agreement, which are our funding charter, were designed to foster stability, trust, and more importantly, coordination among nations. But today's world is very different, as all speakers already mentioned. The current environment is really marked by economic fragmentation, very rapid change in technology, and geopolitical uncertainty. So in this context, how do we apply a legal framework that was conceived 80 years ago? And how do we really preserve the integrity of the institution while ensuring that we remain agile and responsive to the needs of the 21st century? Well, I think the answer really lies in the enduring flexibility of the Articles of Agreement. As you know, Article 1 outlines the IMF's purposes, that is to, I'm going to shorten it, to promote international monetary cooperation, to facilitate balanced growth of international trade, and maintain exchange rate stability. I think these goals remain as relevant today as they were in 1944. So what makes our legal framework resilient is adaptability. Over the past 80 years, we have weathered multiple crises, but we have amended the articles only 7 times. For example, the most consequential amendment was the Second Amendment back in 1978, following the collapse of the Bretton Woods system, which was focused on the fixed exchange rates. This amendment rebalanced the rights and obligations of our member countries and redefined the IMF's role in a world of flexible exchange rates. Other amendments have addressed some very specific issues, such as special allocation of special drawing rights, the basic votes, and election and composition of executive directors' offices, just to name a few. But the evolution doesn't always require a formal amendment. The articles were deliberately crafted to allow for interpretation, providing so-called an architecture that has allowed for evolution without constant amendment. So this has enabled us to address many emerging issues. Let me just give you 2 examples to show how this applied in practice. First, in our surveillance mandate, the global financial crisis showed how economic and financial integration can intensify shocks. and spread the effects of national policies across borders. In response, we shifted our surveillance focus beyond our traditional exchange rates and domestic policies. In particular, back in 2012, we adopted a so-called integrated surveillance decision. This decision established a conceptual link between bilateral and multilateral surveillance to ensure that our surveillance function remains relevant in today's interconnected world. The articles actually did not impose legal obligations on members with respect to multilateral surveillance. But this decision established a procedural obligation for the fund to assess how members' domestic policies affect the international monetary system and also global stability. The second example relates to our lending toolkit. Under the articles, the IMF is required to implement policies for use of our general resources to assist member countries in addressing their balance of payments challenges in a manner consistent with articles and with adequate safeguards for temporary usage. This comprehensive framework enables the fund to adapt its lending policies as members' BOP problems really change with global economic developments. For instance, we were able to promptly provide emergency financing to our members in response to the COVID-19 pandemic, with only modifications to access limits. Basically, we increase access limits to provide more financing to member countries. At the same time, we also managed to maintain robust governance safeguards. We did all this without the need to revise the articles. So what is the role of the legal department in all of this? Well, we are the interpreter, advisor, and guardian of the Articles of Agreement. Like the other organizations, I think colleagues just mentioned, we ensure that the IMF decisions at all levels are consistent with the legal framework and also help shape policies to be legally sound. So in doing so, we complement the political legitimacy of the executive board with analytical and legal legitimacy, both of which are really essential for institutional credibility. To do this, we really need to do a really careful balancing act. On the one hand, exercising the legal agility by finding innovative yet legally sound solutions. On the other, we have to hold the line on what we cannot or should not do under our mandate. As you may know, there's no provision in the articles for judicial review of a decision of any fund organ. We have a tribunal which only deals with administrative law issues, for instance, the employee-related issues. A member may request a formal interpretation of the articles under our Articles of Agreement. Such a request will be put to the executive board with appeal to the Board of Governors, our highest decision-making body, whose decision is final. But this procedure was used only 10 times in the early days of the fund. So in a way, the fund is the sole judge of whether a decision taken by any of its organs is consistent with articles. Also, this power is strengthened by its immunity from judicial process set out in our articles. Experience shows that the fund can operate effectively without any mandatory form of judicial review of its decisions. In this regard, the institution really has placed immense trust in the legal department's judgment on the legality of the decision of a fund organ, and also the trust in our advice for resolving legal issues. So how does the legal department really carry out this role? Let me just highlight 3 key principles that anchor our work. First, not surprising, is independence and objectivity. Our legal advice is impartial, objective, and independent. We're not an advocate for any organ of the IMF or any member country. Our relationship is with the law, not in the institution. Independence and objectivity of legal counsels is essential to the legitimacy and credibility of IMF decisions. This is particularly important given the fact that, as I just mentioned, we don't have an independent dispute resolution process. The second key principle relates to proactive engagement. We collaborate early on with other IMF departments in policy development, providing both policy and legal advice, which may be unique for the IMF legal department. Also safeguarding the boundary between these two. This means that we have a final say on legal issues, but on policy issues, we only provide one of the voices in a policy debate. As you can imagine, mixing these 2 sets of issues could undermine the clarity and credibility of our legal advice. The line between these 2, I have to be very frank, is not always clear. So whether an issue is a legal or policy one must be determined by legal counsels. Finally, clear communication. We need to communicate clearly about what is legally possible, what is not, and try to avoid using all these legal jargons and really explain the rationale, the legal analysis very clearly to our colleagues in various departments and also decision-making organs. This helps get buy-in from all stakeholders. So let me just conclude. The legal department in the IMF is not just a legal gatekeeper. We are also a strategic partner, one that ensures that the IMF remains anchored in the rule of law while evolving to meet the demands of a rapidly changing world. Let me stop here.
Thank you very much, Jan. It was very, very interesting. And I was wanting to continue with the discussion, but I'm looking at the clock and I think that unfortunately we've exhausted already our time. So I would derogate for 5 minutes if there are questions in the room. I had 1 question each for the speakers more, but that will take probably too long. We have gone already beyond time, so if there are no questions, I would like to conclude here. Thank you all for this participation. I think we got a very good perception of the work of these legal services that are different in some aspects, but also they have a lot of common aspects. And what they all do is indeed to promote the rule of law and to preserve the independent advice, which are the very 2 key pillars, I would say. And so I would like to maybe thank you and thank you all your colleagues that behind the screens are working to preserve the rule of law in the legal services of all these institutions. Thank you very much.